And unless there are questions, I'll let Tom.
Before you turn it over to Ms. Ross, sure, give Ms. Luke a chance to respond.
Thank you, Your Honor. Just as there's no precedent for overturning a committee's decision to use their discretion to delegate to members to stand in their behalf, there's also no precedent for overturning a committee's decision that bonds are desirable. We have to look at what the statute requires in this case. And the statute requires a request from the authority. It doesn't require that the authority make particular findings to the committee. It just says make a request. And they did, and I think that defendant's analysis of the request is missing the obviousness of it. The whereas clauses point out who the authority is, what their job is in terms of planning and construction. The fact that the voters have authorized these bonds for the planning and construction of this very project, and then make, again, the very weighty request to the committee saying that we want you to decide that bonds are necessary and desirable. This is a big ask. This is fairly obvious under the statute that issuing bonds would be desirable, but there's no ability to second-guess that decision from the authority. That is within their discretion if they want to make that request. They don't have to support it with particular findings. That is within their discretion. And what I said in the opening and what he said about the public comments issues shows not only the obviousness of the request in terms of the statute, but in terms of the need. No bonds had been issued while the TOS litigation was challenging bond validity. In order to get a validation determination, they would have to authorize bonds. And no bonds have been issued so far. This is something that the authority and the committee would have been well aware of. And it is within their discretion to decide if, given this information, now is a desirable time to issue bonds. The committee, when they get that request, they have to make a finding that it's necessary or desirable to issue bonds, which they did. But they don't have to explain the reasons. They don't have to conduct a hearing. They don't have to take evidence. They just have to make that finding. And again, it is within their discretion and not the place of defendant or I or the court to second guess whether or not they should have waited, done it earlier, later. That is within the discretion of the committee. With respect to the government code section 16724.4, I think this goes into issues we'll get into.
Before you leave that,
yeah.
What if the committee had flipped a coin as to whether or not they should make a determination? Would that be acceptable?
After receiving a request from the authority?
Yes.
I
They
mean,
simply flipped the coin and said, heads is yes, tails is no.
It's within their discretion to make this decision. They had the evidence to make this decision. It's not within, I mean, this is, they obviously didn't do that. But yeah.
I'm just trying to understand the extent of their ability to make the determination.
As long as there's the request from the authority, they have the discretion whether or not they can decide it's desirable or not. So theoretically, I suppose if they decided this question's too hard, I want to flip a coin, it's not within our domain to say they should have made the decision for some other reason. But certainly we can't find that there's no basis for their decision, that it was an abuse of discretion, and that we have to overturn it. Certainly that's not what happened there. With respect to the reporting requirements, they technically kick in, but there's nothing to report until there are uses of proceeds. But either way, this issue is moot because it has nothing to do with bond validity. Whether or not you meet a reporting requirement has nothing to do with the issue here, which is the debt valid? Can it be repaid? There's lots of statutes that the High-Speed Rail Authority will have to comply with throughout the project, which I'm sure we'll be talking about later. But they don't mean that a debt becomes invalid. They don't have to do with authority to issue bonds, authority to repay that debt. Those are separate issues.
Sure. Thank you. Mr. Blackman or Ms. Ross?
Well, let me just put in one more couple of comments on this, and that
give her the last word.
I think that the issue that you asked about flipping a coin is really precisely on point here, which is And I don't have a specific case site, but I know there are a number of case sites that make this point, and that is discretion that an authority or an agency or a committee has is not absolute. It's legal discretion. And it has to be made on a basis that's legally defensible. And in this case, that means there has to be at least some evidence to support that determination. And the mere fact that they were asked to make that determination is not in itself evidence. If the authority had explained why they were making that request right now, what was the reason, then that would have been evidence. But just asking, in other words, somebody asked, can you give me a quarter? Is that evidence saying I should give them a quarter? No, it's just a request.